So today I'm going to explain the difference between negligence and incitement relating to personal injury lawsuits with the help of some of our friends from childhood video games. So let's just say, hypothetically of course, that you're a green dinosaur who happens to love driving his go-kart. You're out one day karting around on Rainbow Road and everything is great. Then all of a sudden, from out of nowhere, this big fuzzy jerk goes zooming by you in his cart with absolutely no regard for the law. He gets in front of your cart and drops one of these things in the middle of the road. The next thing you know, you hit the peel and start spinning out of control. Before you can figure out what happened, your peaceful Sunday drive down Rainbow Road has been totally wrecked by this monkey ape looking thing and this enormous fruit wrapper. And now you're going to have to pay some pretty hefty repair fees to get your cart fixed. Luckily, you would have a pretty strong grounds for a negligence lawsuit here. Donkey Kong had a responsibility to not endanger other drivers on the road, which he violated by dropping the peel. His peel pretty clearly was the cause of your car crash, and you could be financially compensated for both medical bills and car repair bills. In this case, you could sue for negligence and probably win. However, not every case is this simple. Incitement is a tougher standard than negligence. When a personal injury lawsuit is over an act of expression rather than an act of conduct, then it's not enough for the plaintiff to prove negligence. They must prove incitement. This design is intended to protect our First Amendment rights. If negligence was the standard for lawsuits based on expression, it would create a severe cooling effect on free speech. So let's take a look at a second hypothetical situation. You come home after a long day of hypothetical go-kart crashes and lawsuits, and you head over to your Twitter page to tweet the following comment out to your followers. Even if your followers went and egged DK's crib, it's unlikely you would get in legal trouble. This tweet doesn't specifically call anyone into action, meaning that it's not an act of incitement. However, let's take it a bit further and say that instead of that first tweet, you sent out this gem to your tweets. This is much more likely to get you sued if someone follows out your order. Because you are directly calling for people to carry out a specific action, and that call is now documented on Twitter, the plaintiff has a pretty good shot of proving incitement on your part. In this case, you'll probably want to find a good lawyer, or you could end up as a very sad little dinosaur.